Hello, I'm Julie Malcolm, and this is my story regarding my experience with a Jamaican judge who sanctions copyright breaches, to the Constitution of Jamaica and the Copyright Act in particular. As you would have known by now if you have been following my story, I started my MPhil PhD journey at the University of the West Indies. My research in forensic linguistics was claimed by my university appointed research supervisor. I sought to take him to court to have the matter remedied, but I met upon somebody who was extremely kind to him, who occupied the capacity of judge within the Jamaican Supreme Court, and as a result decided to side with the culprit in utter disregard for the Jamaican Constitution. So this video will outline in what ways the Judge Vaughn Smith, breached the Copyright Act, breached the fundamental rights and freedoms, offering equality before the law and freedom from discrimination. So the Copyright Act is a property law, and in Jamaica, the Constitution states that property of every kind is protected. The Jamaican Constitution, Chapter 3, Section 15.1 does state that property of every description is protected. So if it is a pen, if it is a bottle of water, $20 coin, property of every description is protected under the laws of Jamaica. Now, for creatives, the Copyright Act puts in greater detail the various kinds of properties that Jamaicans can enjoy and to what extent they would meet the requirement for protection under our laws. So now we look at the Copyright Act. It does state that based on categorization and authorship, my work qualifies for protection. It qualifies in the category of literary work, which is really my intellectual creations presented in words on a sheet of paper, for example. It does also qualify based on the University of the West Indies standards. I mentioned the University of the West Indies because that is the organization which facilitated the academic relationship that I had with Professor Hubert Devonish, and their policy on intellectual property as it relates to the campus and the dealings on the of staff and students on the university campus deferred to the Constitution of Jamaica. It deferred to the Copyright Act of Jamaica. So any academic work on paper is predominantly considered to be literary work, even the lecture notes. So when I stand before a class to deliver my lecture, the very notes I use to deliver that lecture is protected by law, and the University of the West Indies policies allow for that. So my work is protected based on the requirement of the law that it be in a specific category, and that category in this case is literary work, which is original intellectual creations, words on paper. Another requirement of the Copyright Act is that my work should qualify based on authorship. And what that means is that as an author, I need to be a qualified person at the material time. As a qualified person, I'm Jamaican, requirement filled. Material time, the period of time within which the work was created. Therefore, at the time when my work was created by me, I was a Jamaican, and it can be proven. How do we prove this? The email thread, about 6 or 7 emails between primarily Professor Devonish and I, dated August 6th to 8th, 2016. That is when I outlined my original plan, my original research to Professor Hubert Devonish. And he gave approval. That email is exhibited within the court system, filed within the court system. Another piece of evidence is my progress report, my official progress report, which was created by Professor Hubert Devonish, where he, in his own handwriting, on the 10th of May, wrote about my research that I had created, and he described it as excellent. He described it as impressive. And this is in keeping with his comments in the emails dated August 6th to 8th, 2016, where he said, and I quote, "You have become quite the researcher," end quote. We move now to a third piece of evidence, and this evidence is a letter that I wrote to the campus registrar at the time, Dr. Camille Bell Hutchinson, dated June 6th, 2017. This letter is a comparative analysis of Professor Devonish's letter to the university, where he defrauded the university, where he claimed my research in his attempt to discredit me as the researcher. So the same arrow that he released at me has now turned around to hit him in an uncomfortable place. That letter dated June 6th, 2017 is a comparative analysis of Professor Devonish's May 11th letter in 2017 to the university, and my 28-page analytical plan methods chapter, the core of my research that I had presented to Professor Devonish on the 10th of May. So what he really did was that on the 10th of May, he collected my research, printed 28-page. This is also exhibited. It has also been filed and is within the court system. So he collected my work, he took it home, his handwriting in pen is all over the printed document. And his handwriting on this document matches the handwriting on my progress report dated May 10th. So on the 10th, he collected my 28-page work, he read it, he considered it, he put his inked comments all over it, he wrote on the same day my progress report, dated it May 10th, 2017. Then on May 11th, he wrote a letter and stated that these were his creations. I had nothing to do with them. I wanted nothing to do with them. And as a result, I was not competent to complete the very research that I created. So that June 6, 2017 letter is a comparative analysis of my 28-page analytical plan for my research and Professor Devonish's May 10th progress report of me, and Professor Devonish's May 11th letter to the university that he used to discredit me, to defame me as the author, and to defraud the university that the work was actually his. So let's go through the pieces of evidence again that prove that the work is original and the work was created by me. August 6th to 8th, 2018, the email thread, about 7 emails filed within the court. The progress report that Professor Devonish completed for me and submitted to the University of the West Indies on May 10th, 2017. My 28-page analytical plan that Professor Devonish took, considered, and wrote his comments on. That is dated the 5th of May, 2017. And Professor Devonish's very own letter, the May 11th, 2017 letter that he wrote, where he expressed, he published the work, the creation, as his very own, independent of me. And there's another piece of evidence too. Claimant submissions dated May 18th. May 18th, 2021. All of these documents capture evidence in Professor Devonish's own handwriting, from Professor Devonish's private email, from Professor Devonish's private cellular telephone. So it is not a witness who is coming to lie before the court. It is not me assuming wrongfully. The evidence presented to defend my claim that Professor Devonish breached the Copyright Act are actually documents created by Professor Hubert Devonish. Judge Vaughn Smith, by virtue of the fact that these documents were filed by me or on my behalf in the Supreme Court of Jamaica, Judge Vaughn Smith had access to these documents. The earliest of which was filed in mid-December 2017. He would have presented his decision on May 18th, 2021. Almost 4 years after the fact. So in a case like this, you're going to ask the question, is there any reason for this to be brought up? Who created the work? Julie Malcolm. Was she allowed to enjoy the work without interference from Hubert Devonish? No. What did Hubert Devonish do? He said that her work did not belong to her, but her work belonged to him. Is there any evidence that the work belonged to Hubert Devonish? No. Did Hubert Devonish present any evidence that the work belonged to him? No. Did Julie Malcolm present any evidence that the work belonged to her? Yes. Are these pieces of evidence credible? Yes. They were written by Hubert Devonish's own hand, from his own private email, from his own private cellular telephone. What does the law state? The law states that if the original work of a person is taken, is claimed, is used without permission by another person, then the unauthorized user of the work is guilty of breaching the Copyright Act. Does Judge Vaughn Smith know this? Yes. Did he agree with this? Did he stand by the laws of Jamaica? No. What did he do? He decided that Hubert Devonish was not in breach of the Copyright Act because Julie Malcolm was a student at the time when Hubert Devonish claimed Julie Malcolm's work. But this very decision of Judge Vaughn Smith is in breach of Chapter 3, Section 3G of the Constitution of Jamaica, which states that all Jamaicans have equality under the law, the right to equal treatment under the law. The Copyright Act also states that, see if I can find it, an original work qualifies for protection regardless of the quality of the work or the purpose for which it was created. So in my case, my work, the purpose of my work was in partial fulfillment of my PhD degree at the University of the West Indies. That's the purpose. So therefore, I would have had to be a student of the university to fulfill that purpose. My position of a student in pursuit of academic excellence cannot be used against me to prevent me from receiving copyright protection under the laws of Jamaica. Deciding that I do not qualify for copyright protection because I am a student is in breach of my constitutional right for equal treatment, for fair treatment. Judge Vaughn Smith is guilty of discrimination under the laws of Jamaica. Constitution of Jamaica, Chapter 3, Section 16.2 and 16.3 state that I have the right to due process. I have the right to have this matter dealt with in the court within a reasonable time by an impartial court or an impartial authority. Judge Vaughn Smith has not allowed for that to happen. We know that whatever happens in the court is public. Any court in Jamaica is public. So the decisions of the judge, public. The justification for said decisions, public. However, since Judge Vaughn Smith made his decision, I have not been in receipt of any written reason for his judgment. When I wrote to the Supreme Court, I was told in a response email that the decision of the judge is not available to me. I do not qualify for it. I am not entitled to it. And this is a thread of emails. When I reported this to Court Administration Division, the link to all the documents that I have within this video and other documents, the source of the link, was hacked. So all the documents that I have up here in this video and those that are not in this video were removed from the link to the complaint that I made to the Court Administration Division. I have since written to the Court of Appeal because the matter is up for appeal. The Court of Appeal has told me that they are not in receipt of any reasons for any judgment in my case made by Judge Vaughn Smith. If your decision is legal, stand by it. If your decision is illegal, stand by it. Release it. So right now, I do not have a date for my appeal. Even though the appeal was filed in summer of 2021. So Judge Vaughn Smith has either not written his reasons, or the Supreme Court has decided that they are not going to release the reasons, or they have, and the Court of Appeal has decided that they're not going to release it to me. But I need those reasons in writing so that I can move forward with the appeal. We know, Judge, that your decisions were not made based on the Constitution of Jamaica. Your decision is going to be overturned because it has no basis in law. And it was a cut and clear case. Julie Malcolm created the work. There is sufficient proof. Professor Devonish falsely claimed the work. There is sufficient proof. But yet you found that he did nothing wrong, that I was not qualified for protection under the law. This is where you take it back in this appeal. Release your decisions to the Supreme Court. Supreme Court, release it to the Court of Appeal that I may access said decisions. Because it makes no sense that from the age of 19, I dedicated my life in service of this country through the education system. And I am now being prevented from completing my own education by my CARICOM brother, a Guyanese native, Professor Hubert Devonish. So he stole my work, and you, Judge Vaughn Smith, drove the getaway car. If a man steals my donkey and you drove the getaway car with the man and my donkey, you are equally responsible. So in this case, Professor Devonish stole my research. and Judge Vaughn Smith drove the getaway car. It even feels wrong rolling off my tongue. Chief Justice Brian Sykes, DPP Paula Llewellyn, Court Administration Division, you have the authority here. The ball is actually in your court. Do we as a society continue to view the law courts as a place where we can go to seek redress when we have been hurt, when our rights have been infringed? Or do we, starting from this case, begin to see judges as protectors of criminals, judges as persons with a personal agenda? And my question for Judge Vaughn Smith: why you do it? Why you do it, Judge? We know you did not do it for law. Were you bribed? Were you blackmailed? Were you threatened with physical violence? Or was it just a favor to the favor of a loyal friend? Why you do it? How could you sanction copyright breaches in this case when the law is clear? There are no sharp corners. There are no gray areas. Why did you do it? Please release your reasons. Time is against us, as you well know. And let us continue. Let someone else interpret the Constitution the way it was meant to be interpreted, because clearly you lack the ability so to do. I'm Julie Malcolm, and this is my story.